Hello, and welcome to Williams Mullins's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets, such as patents, trademarks, copyrights, and trade secrets. I'm your host, Carmelle Alipio, and today I'll be joined by Janet Cho, a partner in our intellectual property group here at Williams Mullen. Today, we're diving into cease and desist letters. We'll explore why they matter in protecting your intellectual property and the elements of effective letters. Hey, Janet, how are you?
Good, Carmel. Thank you for having me.
Have you heard about the cease and desist letter that the New York Times sent to an AI company demanding that they stop using New York Times content to train their generative AI products?
I have, and I think this issue of what I will call cease and desist letters, or maybe some called C&D letters or demand letters, or even notice letters, is pretty timely. And I don't know that their relevance ever really went away, but it's certainly coming up in the context of AI and some other things going on with technology for sure. So it's definitely, I think, a good time to talk about this or revisit it for some.
Why don't we start there? Could you please give us a background on what a cease and desist letter is for any listeners out there who aren't familiar with the term?
Sure. And I'll start by saying a little bit about what cease and desist letters are and also what they're not. So, at its core, a cease and desist letter is a form of communication to another party who is ostensibly adverse to you relating to some aspect of your intellectual property or an interest of the sender. It is not a lawsuit. And I want to be really, really clear because I think sometimes when parties send demand letters, there's a lot of emotion involved and things can get stirred up very quickly. And so it's not something that necessarily in and of itself compel another party to do something or not do something, but it's certainly a first step in terms of communicating what your rights are and who you are and what you'd like the other side to do. And that could be something extremely limited and discreet, or it could be very broad and complicated. So it's really all about putting another party on notice of your rights and what you'd like them to do. And it can be a first step or a preliminary step in resolving an IP dispute, one that's ongoing or perhaps one that's emerging. So I think it's helpful to kind of um, get the ball rolling in terms of resolving a dispute or a potential dispute.
Is it fair to call the first cease and desist letter or demand letter, as you called it as well, a formal warning about what could happen?
I think absolutely it can be a first step in terms of a formal warning, but it also depends on what you're trying to accomplish with the letter. And I know we'll talk about that. There are many different ways that a letter can be drafted, what you can include, what you can direct to the other side. But I think in its most popular understanding, a cease and desist letter or a C&D letter is in fact something fairly, maybe not aggressive, but definitely prohibitive in terms of we think you're doing this, we want you to stop doing this. So it's certainly more in the realm of a warning than it is an amicable communication, I think, most times.
What kinds of intellectual property can a cease and desist letter protect?
Well, I would say a cease and desist letter can pertain to or encompass pretty much any type of intellectual property that a party is looking to protect or make another party aware of. So it might be trademarks, whether that's registered or unregistered, copyright rights, again, whether registered or not, patentable subject patents, and maybe proprietary information or technology and trade secrets. So it's pretty broad. I would say, for ease of reference, anything in that realm that the sender believes that they have a right to or is protectable in some way, shape, or form is something that a demand letter may cover.
So when should a sender consider sending one?
That's a very good question. And I think before we get into it, I really want to emphasize what's important here before you actually send the letter, because once you send that letter, it's very difficult, I would say, to call back the effects and just the letter itself. So I would encourage all of our listeners to do diligence or conduct research before any letter is sent. And that is the research. I would encourage everyone to essentially cover, what do you think your rights are? So if you're asserting, say, trademark rights or patent rights, making sure that those rights in fact exist. They cover what you think they cover or what you plan on addressing in the letter, and that they're valid. So they're not abandoned or expired, and that you have the rights in the jurisdiction you think you have them. So your mark, for example, in the realm of a trademark, if your mark is registered, say in Canada, but it's not yet registered here in the US, and that's really what the letter is intended to encompass, you want to make sure that your rights align with what you're about to assert. And also to make sure that what you are about to allege is infringing or misappropriating is in fact that type of conduct, and it's not fair use. It's not something that's protectable under some other aspect of the law. And certainly when it comes to trademark rights, you want to make sure that you're the senior user or your rights are senior. One potential risk of issuing a letter without doing diligence is you assert that you have superior rights, and in fact you're not the superior right holder, and you end up being the junior right holder. And you may have, in turn, through that communication, if it's not properly vetted, put yourself in a situation where now someone else or that party that you initially sent a demand letter to is going to challenge your use as a junior user. So I think it's important to definitely do your diligence. And when to send one depends on, again, what you're trying to accomplish. You may want to stop another party from using or commercializing some aspect of your intellectual property. It could be that you just want to invite a dialogue. You want to talk about, we're in this commercial channel. We think you're in this commercial channel. Maybe we can talk about how we can both get what we want out of a particular arrangement. So it's really to accomplish what you as the rights holder would like from the other side. And that's a very vague statement, but it's really to try and move a process along so that you can best protect your intellectual property and start the process. And that can be maybe more assertively or stridently worded, or it could be more amicably worded, depending on, again, what you're trying to accomplish.
Janet, let's talk about, what are the effective key elements of a strong letter? Where would you start?
Well, that's a very good question. And I think the very first thing to consider is identifying who you are as the sender. So, if, for example, in the case of a party that maybe has one presence commercially, so they're known to the public as XYZ, but the owner of the IP is actually, say, a holding company or a subsidiary or a parent that perhaps the public would not necessarily be aware of, then that's something that should be elaborated. And I think sometimes the public sort of may believe that they know who the owner of IP is based on the public facing brand, but those two things are not necessarily always in sync. So to be very clear about who is sending the letter, so that if anything, the recipient knows where and to whom to send a potential response.
Besides identifying the correct intellectual property owner by name, are there other details that our listeners should consider when it comes to identifying the sender?
Well, I think that as part of that, in addition to elaborating the specific, say, entity or party, also providing context to what the party does commercially and what their business is. And part of that is to make clear in what commercial space or channel you're operating, so that you can let the other side know, we are in the realm of, say, consumer goods products, And what you're doing, recipient, is also either one in the same space or in a complementary or related space. So certainly elaborating something about your business and why you believe there's some risk of confusion or misunderstanding by the public.
Understood. So after we clearly identify the sender, what should we include next?
I think what's important, and this is likely to be one of the most important elements, maybe not the most important, but describing what the other side did or did not do that you as the sender believe is infringing. So, and being very specific about that. So if you can, provide, say, a date or dates, or provide the medium or mediums. So if there was some mention on a website, say, to either provide a link to that or include screenshots as exhibits. And also, if you can, the specific party of the sender who did that. So if it was, a particular individual who posted a comment, or if it was a particular department who did something, to provide all of that information. Because what you want to neutralize is the other side saying, well, we don't have enough information, or that wasn't us. So if you provide as much detail, then you can, as best you can, hopefully tie it to your recipient, and it becomes more difficult for them to evade or disavow their conduct to you.
It sounds like that goes directly into the diligence that you were talking about earlier in terms of identifying who the potential infringer is. Is that right?
I would say that's true, and sometimes it's difficult because, for example, in the case of trademarks, sometimes, and this may be the case for patents as well, sometimes depending on the type of intellectual property, you can find some information about your recipient publicly online if certain aspects of, other intellectual property they own is made of public record, or sometimes if it's in another jurisdiction and they have something registered, you can find that. But sometimes you may be in a situation where you are trying to send a letter based on the information best available to you, and it's, I think, ultimately in the sender's judgment as to when do you feel you have enough information that you feel comfortable sending a letter, knowing that this might not be accurate, knowing that I might not get a response, and how do you plan for that?
That all makes sense. Okay, so we've got a clear identification of the sender, a detailed description of the infringement. What do we include in next?
I would encourage including the relevant legal rights that you believe are either being infringed or that you're asserting. So if it's copyright rights, to note the type of right, and if there is something registered or something specific that you can tie that right to, so a registration number, a patent number, or something along those lines, I think that's important. I think most of the time a demand letter is an enforcement tool, and you want to include all of the, as a brand owner or as an IP rights holder, you want to include as much as you can from your portfolio of potential enforcement tools to not only notify a third party of your rights, but to persuade them of your rights and what you're trying to get them to do in that letter. And I think citing to registration numbers or long-standing use or something along those lines that can be more probative or more, again, more persuasive would be helpful to include. And also, I think recipients sometimes believe that, well, if you're not asserting something registered, then I suppose I don't have to respond to this. So I think it's really imperative, if you have something that's registered, or if you can point to what type of rights you have and why, that's crucial to include.
And after we include the sender's name, the description of the infringement, the legal basis or the intellectual property right that we have over the relevant intellectual property, what do we do next?
I think it's important to elaborate what you are directing the other side to do. So make clear whether it's a demand or perhaps it's a request, but whatever you are asking of the other side, to make that very clear. So if it's to stop an activity, to note that and to specify all of the different realms or mediums in which the cessation of the activity applies. If it's to remove content, again, to specify the locations or the mediums in which that removal should occur. If it's to make an attestation or a declaration, to maybe, if you can, provide a form of that to the other side. So if you are asking them to attest that they have destroyed something, to append to your letter a form of declaration that they can easily complete and send back to you. In all of this, part of what you're trying to do, especially with forms like that, is to make it as easy as possible for the other side to comply. So to do that, or if it's to make a phone call to you or to reach out to someone within your business, to provide the contact name or the email or the phone number so that it's easy for the other side to reach out to whoever you want that other party to reach out to.
How long should you give the other side to comply with that request?
That is a good question, and I think it depends on, one, how urgent the issue is. So if it's infringement and you truly believe that it is harming your assets, then I think a shorter timeline is likely going to be more reasonable. If you are trying to be amicable, then a longer time frame, I think generally something between 7 and 14 days is likely reasonable, but I know I've seen response directives that are 3 business days. Sometimes it's 30 days. And again, it really depends. Sometimes if you are sending a letter and there's a holiday that falls in between there or in and around which you'd like to see a response about, I think strategies differ. Some people make room for the holiday after. If you really wanted to be very, very demanding, you can, demand a response the day before the holiday. So it really all depends on what you're trying to accomplish and the message you're trying to send through your letter.
What happens if a potential infringer decides to ignore the letter? Should a sender include potential consequences in there?
I think you can. One thing I want to emphasize is that a letter is just that. It is not a vehicle through which you can compel someone to stop a behavior or to engage in a behavior. So you're elaborating what you want the other side to do, but the letter itself, without more, can't compel someone to do something. So that's important to know. And I think before you issue the letter, it's important for the sender to contemplate that and think about, okay, what if the person doesn't respond? You can certainly sometimes send a follow-up letter, and very often that may be persuasive. Sometimes parties think, if I just ignore the letter, it will go away. And if they receive a second letter, they take it a little bit more seriously. If the letter is not responded to, there may be what I might call the business to business option. And this doesn't apply to every circumstance, but if the letter is not responsive, but you definitely want to have some sort of engagement, if people within the two sides have a common contact, maybe they reach out to one another or make a phone call to try and resolve it business to business or informally. So that's one option. Another option, depending on what is at stake and how aggressive you want to be, if there's no response, one potential avenue is to commence litigation against the other party. And I think before you do that, it's something that should be thought through and also diligenced. But the responses after a lack of engagement from the other side are just are as varied as the type of letter that a party can write.
Let's turn now to common mistakes to avoid. Let's assume that our listeners have thought through the why and decided a letter is the best route here. What would you recommend a cease and desist letter should not include?
Absolutely. And I think that these are all considerations that should be thought through before issuing the letter. And again, I know that sometimes when demand letters are about to be sent out, there can be a high level of emotion. So it's always reasonable to step back a little bit and think through, okay, what do I really want out of this letter or out of this potential engagement with the other side? And let's think about the best way to get what we want. One thing to think about is the tone and the demand or the request or directive in the letter, and thinking very carefully about, is this the very hyper aggressive letter, or is this more of a perhaps neutral letter? And one thing that I would just have our listeners think about is being overly aggressive or threatening may not get you to where you want to be, because ultimately you want the other side to comply with or do what you've asked them to do. And the trickiest thing, I think, or one of the tricky things about a demand letter is that sometimes you don't know who you're writing to, or sometimes you know who you're writing to and you're not clear on how they're going to respond. The other side may have a host of considerations that are different from yours as the sender, or they're just different because they're a different business. So it's very difficult to anticipate what they're going to consider in their decision making and how they're going to respond to your letter. So I think thinking through what you, as best you can, believe is going to encourage, if not a dialogue, compliance, or I don't want to say concession, but some sort of cooperative scenario where you can get to a place to resolve your issue. And again, going to your point about diligence, it's important to make sure that you have the rights you say you do, and that what you say you own, you in fact do own, and also making sure that the other side's conduct is in fact actionable. Because if it's not, and say it falls under fair use, then that's not a good fact for the sender. And I would also say you want to make sure that your letter is tailored to the circumstance, as opposed to, say, copying and pasting a letter from, say, that you found online or a template or something like that, making sure that your letter is very tailored to the circumstance at hand.
When should our listeners consider getting a lawyer involved?
Oh, Carmelle, you're asking all of the hard questions today. um, I think sometimes that can be a very tough call. And I would say it depends on what specifically you're trying to accomplish with the letter, and perhaps what other resources you as the potential sender have. So, and what I mean by that is sometimes when you're in a demand letter situation, it could be that your potential addressee is actually has a business relationship with you. So, for example, they may be a customer or a vendor, and you want a narrow outcome. You want them to stop using a particular mark of yours. It could be that if you believe there's more to be gained or more progress to be had, if your business person contacts some business person within the vendor and you can resolve it informally, then perhaps that's what you do, or you at least start there. Sometimes conversations like that don't go well, and so that's the time to get the lawyer involved, where informal discussions have not been very fruitful. Sometimes clients want a lawyer to write the letter, especially if they want to be a little bit more assertive or strident, and they want that to come from the lawyer because they think it will be more persuasive that way, as opposed to if the business wrote that. The other thing is sometimes parties will do a mixture of what I've just described, which is they have a lawyer draft the letter, but it comes under the letterhead of the business. So it feels as though this is somewhat more of a amicable approach, but because a lawyer drafted it, it covers all of the relevant legal points. But I think definitely if it's high value IP or if it's particularly egregious infringement, however you as the potential sender define that, then I think that might be the time to get a lawyer involved. And certainly if the demand letter is accompanied with a particular type of remedy that requires court action, say an injunction or something along those lines, that may be the time that you consider getting a lawyer involved.
Thanks, Janet. That's super helpful. I'll just give a quick recap of what I thought were the most important points that our listeners should definitely take away from this. And please jump in if you think I'm missing anything. But for me, the biggest takeaways were first, doing your diligence before writing the letter, being able to identify who you are as the sender to make sure that you know that you own the intellectual property at issue, that you've tried to look into the other side to see if their use is infringing yours, or if they are, in the case of trademarks at least, a senior user to you. And that also means making sure that you're going to write the letter to the right entity. Next, I think you also stressed on the why. Why should the letter be sent out? Do we have a case of high value IP being infringed? Is there ongoing infringement that's happening? And third, avoiding being overly aggressive or threatening unless that's the point. We want to make it as easy as possible for the other side to agree to our demands. So being realistic with the ask and making sure that it is something that they can actually comply with in a reasonable amount of time will help us and our clients get to the outcome that they want. Is there anything else that you think we should highlight for our listeners?
Carmel, I think that was a very helpful summary. The only additional points I would raise is issuing a demand letter is not an entirely risk-free enterprise. And I think our listeners know this to some extent, but one, if you send a demand letter to a party and the letter is overly aggressive, meaning it contemplates litigation, it's very possible that the receiver decides that if they anticipate a dispute, they may go to a court in their home territory and seek what's called a declaratory judgment, which means that they want a court to decide that they are not an infringer. And so what that does is it means that your addressee or your recipient has actually commenced a type of litigation in their home territory, and your infringement claim potentially becomes a counterclaim in a jurisdiction you weren't anticipating. So if you, as a sender, are in New York and your recipient is in Washington State and they commence a declaratory judgment action in Washington State, then you, as a New York entity, will have to go to Washington to defend the declaratory judgment action. So it's something to think about. It's not to say it will happen, but it's definitely in the panoply of risks in sending out a demand letter, one thing to certainly be aware of. The other thing is, in this day and age of demand letters, your demand letter may end up being circulated online or publicly. And sometimes parties don't, this is not a consideration for them, but if you don't want your letter published publicly or you don't want to have any negative goodwill associated with that, think about how you actually write the letter, because you may win, quote unquote, against your recipient, but you may actually suffer some brand damage if that letter is not written in a way that is favorable to you and it's published publicly, and the public believes that you are unnecessarily bullying a party. And that may not even be legally true, but it could potentially affect your brand recognition. So those are the only things I would mention, but I think that you summarized it very well.
Those are great points. Thank you for joining me today, Janet. I believe that will wrap up our discussion on cease and desist letters and this episode of Trending Now, an IP podcast. Listeners, if you have any questions or suggestions for future episodes, or questions on what to do if you're on the receiving end of a cease and desist letter, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening. Until next time.